Property 424. Ch12, Restrictive Covenants. A. Introduction. The historical antipathy of English law toward negative easements, the right of a landowner to prevent particular uses of someone else's land, made private ordering over conflicting land uses somewhat difficult. The basic problem is relatively easy to understand. Suppose Abigail pays her neighbor Beatrice $1,000 in exchange for a promise that Beatrice will use her land only for residential purposes, because Abigail does not want to live next door to a busy commercial or industrial facility. Suppose that Beatrice then begins to construct a factory on her land. Abigail could sue for breach of contract and obtain appropriate remedies, perhaps including injunctive relief barring Beatrice from building the factory. But now suppose that instead of building a factory herself, Beatrice sells her land to Clara, who intends to build a factory on the land. Clara didn't promise Abigail anything, and Abigail gave Clara no consideration. They are not in privity of contract. We might therefore conclude that Abigail is out of luck. She cannot enforce a contract against someone who didn't agree to be bound by it. But if that is our conclusion, there is now a huge obstacle to Abigail and Beatrice ever reaching their agreement in the first place. How could Abigail ever trust that her consideration is worth paying if Beatrice can deprive Abigail of the benefit of the bargain by selling her, Beatrice's, land? More generally, if a promise to refrain from certain uses will not run with the land, can private parties ever effectively resolve their disputes over competing land uses by agreement? Notwithstanding this concern, English courts were historically quite resistant to enforcing such restrictions against successors to the promisor's property interest. As you've already learned, only a very small number of negative easements were recognized. Furthermore, actions at law seeking the remedy of money damages for breach of a covenant restricting the use of land were available only in quite limited circumstances, in cases involving landlord-tenant relationships. Early American courts were more willing to enforce such covenants outside of the landlord-tenant context, but still required quite strict chains of privity of estate, voluntary transfers of title by written instruments before they would enforce such. Ch12, Restrictive Covenants 425. Covenants by an action for money damages. Of course, where the dispute is over competing uses of neighboring land, perhaps money damages are not the appropriate or even the desired remedy. And herein was the key to substantial liberalization of the enforcement of restrictive covenants. Eventually, landowners with an interest in enforcing such covenants found a workaround. Tulk v. Mahe. 1845-47 Eng. Republic 1345. Leicester Square in the 18th century. Source: John Hollingshead, The Story of Leicester Square 1892, available at British Library Online. http://access.bl.uk/item/pdf/lcitv3c48bb3a. This was a motion by way of appeal from the Master of the Rolls to dissolve an injunction. In the month of July 1808, the plaintiff was seized in fee simple not only of the piece of ground which formed the open space or garden in Leicester Square, but also of several houses situated in that square, by an indenture of release, dated the 15th of July 1808, and made between the plaintiff, of the one part, and Charles Elms, of the other part, after reciting that the property 426 plaintiff was seized of that piece of land in fee simple, and had contracted to sell it to Elms, but not reciting that that contract was made subject to any condition. In consideration of £210, the plaintiff conveyed to Elms, in fee simple, all that piece or parcel of land, commonly called Leicester Square Garden or Pleasure Ground, with the equestrian statue then standing in the centre thereof, and the iron railings and stonework round the garden, and all easements or ways, and c. to hold the same to Elms, his heirs, and assigns for ever. And in that indenture there was contained a covenant by Elms, in the words following, and the said Charles Elms, for himself, his heirs, executors, administrators, and assigns, doth covenant, promise, and agree to, and with the said Charles Augustus Tulk, his heirs, executors, and administrators, in manner following, that is to say, that he, the said Charles Elms, his heirs, and assigns, shall and will, from time to time, and at all times for ever hereafter, at his and their own proper costs and charges, keep and maintain the said piece or parcel of ground, and square garden, and the iron railing round the same, in its present form, and in sufficient and proper repair as a square garden and pleasure ground, in an open state, uncovered with any buildings, in a neat and ornamental order, and shall not nor will take down, nor permit or suffer to be taken down or defaced, at any time or times hereafter, the equestrian statue now standing or being in the centre of the said square garden, but shall and will continue and keep the same in its present situation, as it now is, and also, that it shall be lawful to and for the inhabitants of Leicester Square, aforesaid, tenants of the said Charles Augustus Tulk, and of John Augustus Tulk, esq. his father, their heirs and assigns, as well as the said Charles Augustus Tulk and John Augustus Tulk, their heirs and assigns, on payment of a reasonable rent for the same, to have keys, at their own expense, and the privilege of admission therewith, annually, at any time or times, into the said square garden and pleasure ground. The bill then stated, that, the defendant had become the owner of that piece of ground by virtue of a title derived from Elms through several successive conveyances, and that he had formed a plan, or scheme for erecting certain lines of shops and buildings thereon, but that the plaintiff objected to such scheme, as being contrary to the aforesaid covenant, and injurious to the plaintiff's houses in the square, that the defendant had, nevertheless, proceeded to cut down several of the trees and shrubs, and had pulled down part of the iron railing, and had erected a hoarding or boards across the said piece of ground. Ch12, Restrictive Covenants 427. The bill charged, that, at the time when the defendant purchased the piece of ground, and also when he took possession thereof, and also when he committed the acts complained of, he had notice of the covenant. The bill prayed, that the defendant, and his agents and workmen, might be restrained from doing or committing, or permitting, or suffering to be done or committed any waste, spoil, destruction, or nuisance to be in or upon the said piece of garden ground. An ex parte injunction was obtained from the Master of the Rolls, and the defendant, by his answer, stated, that the inhabitants of Leicester Square and of the plaintiffs' houses had entirely ceased to use this piece of ground as a garden and pleasure ground, or to pay any sum for the privilege of admission, and that, for many years before the defendant purchased it, it had been in a ruinous condition, and not in an ornamental state, but altogether out of repair, that Tulk never took any steps to enforce the covenant, or to have the site of the ground improved, that the square was no longer a quiet place of residence, but that a thoroughfare had lately been made through it from Long Acre to Piccadilly, that he proposed to open 2 footpaths diagonally across the square, putting up gates and fences, that he had not yet fixed on any plan for building on it, or as to the ultimate use he should make of it. But he reserved by his answer the right to make all such use of the land as he might thereafter think fit, and lawfully could do, and he also submitted to the court, that the covenant did not run with the land, and did not bind him as assignee. The defendant applied to the Master of the Rolls to dissolve the injunction, which his lordship refused to do. The effect of the injunction, as varied, was to restrain the defendant, his workmen, and c. from converting or using the piece of ground and square garden in the bill mentioned, and the iron railing round the same, to or for any other purpose than as a square garden and pleasure ground, in an open state, uncovered with buildings, until the hearing of this cause, or the further order of this court. The motion to dissolve the injunction was now renewed before the Lord Chancellor. Property 428. The Lord Chancellor Cottenham. It is not disputed that a party selling land may, by some means or other, provide that the party to whom he sells it shall conform to certain rules, which the parties may think proper to lay down as between themselves. They may so contract as to bind the party purchasing to deal with the land according to the stipulation between him and the vendor. Here, then, upon the face of the instrument, and in a manner free from doubt, the owner of the houses sells and disposes of land adjoining to those houses with an express covenant on the part of the purchaser, his heirs, and assigns that there shall be no buildings erected upon that land. It is now contended, not that Elms, the vendee, could violate that contract, not that he could build immediately after he had covenanted not to build, or that this court could have had any difficulty, if he had made that attempt, to prevent him from building, but that he might sell that piece of land as if it were not encumbered with that covenant, and that the person to whom he sold it might at once, without the risk of the interference of this court, violate the covenant of the party from whom he purchased it. Now, I do not apprehend that the jurisdiction of this court is fettered by the question, whether the covenant runs with the land or not. The question is, whether a party taking property with a stipulation to use it in a particular manner, that stipulation being imposed on him by the vendor in such a manner as to be binding by the law and principles of this court, will be permitted by this court to use it in a way diametrically opposite to that which the party has stipulated for. Of course, the party purchasing the property, which is under such restriction, gives less for it than he would have given if he had bought it unencumbered. Can there, then, be anything much more inequitable or contrary to good conscience, than that a party who takes property at a less price because it is subject to a restriction, should receive the full value from a third party, and that such third party should then hold it unfettered by the restriction under which it was granted? That would be most inequitable, most unjust, and most unconscientious, and, as far as I am informed, this court never would sanction any such course of proceeding, but, on the contrary, it has always acted upon this principle, that you, who have the property, are bound by the principles and law of this court to submit to the contract you have entered into, and you will not be permitted to hand over that property, and give to your assignee or your vendee a higher title, with regard to interest as between yourself and your vendor, than you yourself possess. Ch12, Restrictive Covenants 429. That is quite unconnected with the doctrine of a covenant running with the land. There is no question about the legal liability, which is best proved by this, that if there be a merely legal agreement, and no covenant, no question about the covenant running with the land, the party who takes the land takes it subject to the equity which the owner of the property has created, and if he takes it, subject to that equity created by those through whom he has derived a title to it. Is it not the rule of this court, that the party, who has taken the property with knowledge of the equity, is liable to the equity? Is not this an equity attached to the property, by the party who is competent to bind the property? If a party enters into an agreement for a lease, and then sells the property which was to be demised, the purchaser of that property, with knowledge of the agreement, cannot set up his title against the party claiming the benefit of that contract, because, if there had been an equity attaching to the property in the owner is not permitted to give a better title to the purchaser with notice than he himself possesses. The other party is entitled to the benefit of the contract, and to have it exercised and carried into effect against the person who is in possession, unless that person can shew he purchased it without notice. Here there is a clear, distinct, and admitted equity in the vendor, as against Mr. Elms, and as to the party now sought to be affected by it, it is not in dispute that he took the land with notice of the covenant. Indeed, it appears on the face of the instrument which is the foundation of his title. It seems to me to be the simplest case that a court of equity ever acted upon, that a purchaser cannot have a better title than the party under whom he claims. Without adverting to any question about a covenant running with land or not, I consider that this piece of land is purchased subject to an equity created by a party competent to create it, that the present defendant took it with distinct knowledge of such equity existing, and that such equity ought to be enforced against him, as it would have been against the party who originally took the land from Mr. Tulk. I think, therefore, that the Master of the Rolls is quite right, and that this motion must be refused, with costs. Notes and questions. 1. Is the result in Tulk attributable to a difference in the willingness of courts of equity, as compared to courts of law, to find a covenant will run with the property 430? Land? To the principle of nemo dat? To the rules regarding good faith? Purchasers? To something else? 2. Is the result in Tulk consistent with the principle of numerus clausus? With the common law policy against restraints on alienation? 3. Tulk v. Mahe represented a new opening for private ordering regarding competing land uses, which hinged on the distinction between law and equity. In the end, the equitable exception swallowed the legal rule against restrictive covenants running with land. As one court explained, in the past, some courts have distinguished between a real covenant that runs with the land and an equitable covenant, sometimes called an equitable servitude or equitable restriction, that runs with the land. Today, however, the restatement, third, property servitudes, sensibly explains the differences between covenants that historically could be enforced at law and those enforceable in equity, have all but disappeared in modern law. Continuing use of the dual terminology of real covenant and equitable servitude is confusing because it suggests the continued existence of two separate servitude categories with important differences. In fact, however, in modern law there are no significant differences. Valid covenants, like other contracts and property interests, can be enforced and protected by both legal and equitable remedies as appropriate, without regard to the form of the transaction that created the servitude. Lake Limerick Country Club v. Hunt MFG. Homes Incorporated, 120 Wash. App 246. 253-54, 84p.3d 295, 298-99, 2004, footnotes omitted. 4. It is worth noting again that the third restatement, quoted in Lake Limerick Country Club, is somewhat unique in not simply restating the law but also pushing it in a particular direction. Many jurisdictions have yet to adopt its more modern approach on merging the various servitudes, or on other Chap12, restrictive covenants 431. Important issues. As always in property law, it is important to consult the relevant authorities in your jurisdiction in order to determine whether courts there still follow more traditional rules regarding the creation, enforcement, modification, and termination of restrictive covenants. 5. Put another way, isn't the problem here reciprocal in that the parties simply have incompatible land use preferences? Thus, when Lord Cottenham rhetorically asks, is not this an equity attached to the property, by the party who is competent to bind the property, is he merely assuming the initial allocation of the relevant entitlement to the party that was there first? If so, is the application of a restrictive covenant to successors a circumstance in which the parties could effectively bargain to reach the efficient result? 6. Recall the dispute between Abigail, Beatrice, and Clara. Does the principle of first in time is first in right provide any reason to privilege Abigail's preferred use of Clara's land over Clara's preferred use? Does the fact that Abigail and Beatrice reached their agreement before Clara became involved suggest that, as a matter of general property law principles, later comers will have to either abide by that agreement or obtain both parties' consent to abrogate it? Is such a rule necessary to protect Abigail's legitimate expectations with respect to the use and enjoyment of her own property? 7. More generally, are the arguments supporting the principle of priority in time persuasive when applied to land use conflicts, as opposed to disputes over title or possession? Conversely, if we do allow agreements like the one Abigail and Beatrice to run with the land, are we giving past owners too much control over the ability of present and future owners to adapt their land uses to changing circumstances? B. Creation of an enforceable restrictive covenant. As courts became more amenable to the enforcement of restrictive covenants by and against successors to the property interests of the original covenanting parties, they developed a set of requirements for such covenants to run with the land. As one court described these requirements. Property 432. The prerequisites for a covenant to run with the land are these: 1. The covenants must have been enforceable between the original parties, such enforceability being a question of contract law except insofar as the covenant must satisfy the statute of frauds. 2. The covenant must touch and concern both the land to be benefited and the land to be burdened. 3. The covenanting parties must have intended to bind their successors in interest. 4. There must be vertical privity of estate, i.e., privity between the original parties to the covenant and the present disputants, and 5. There must be horizontal privity of estate, or privity between the original parties. Leighton v. Leonard, 589 p.2d 279, 281, CT App Washington Div 1 1978. A further requirement is that a restrictive covenant is enforceable only against parties who are on actual or constructive notice of it. CID at 281 to 282, Accord Inwood N. Homeowners Association, Inc. v. Harris, 736 S.W.2d 632, 635, Texas 1987. 1. Implied reciprocal servitudes, an exception to the rule. Notwithstanding those general requirements for creation of an enforceable covenant, courts in many, but not all, jurisdictions have recognized implied reciprocal negative servitudes in a limited range of contexts. Consider the following decisions. McQuaid v. Wilcox, 183 NW 771, Michigan 1921. Opinion by Fellows, J. In 1910, defendant Mary Millington Wilcox was the owner of 105 acres of farmland. lying along Woodward Avenue at the 10-mile road. It was over in Oakland County, and near Royal Oak. She and her husband, an attorney then practicing in Detroit, conceived the idea of platting a portion of it for a high-class residential subdivision. The plat was prepared and recorded. Its residential and restricted character was made the subject of advertisement and pointed out in conversation as an inducement to prospective purchasers. A general plan was adopted to make it a high-class restricted residential district. A considerable number of men, many of them with children, growing up, desiring a home in such a district, purchased lots. Substantial homes were built and an additional subdivision was platted adjoining it. To ensure and Ch12, Restrictive Covenants 433. Preserve the residential character of the subdivision, substantially uniform restrictions were inserted in the deeds executed by Mrs. Wilcox to the purchasers. We quote the restrictions found in the original conveyance of the lot now owned by plaintiffs. McQuaid. It is agreed that said lot shall be used for residence purposes only, that only 1. Single residence shall be placed thereon, the value of which shall be not less than $3,000, the front wall thereof to be at least 50 feet from the front line of the lot and the side wall not less than 20 feet from the side line of the lot, and all other buildings in the rear of the lot and at least 150 feet from the street line. A sewer may be made and perpetually maintained along the rear line of the lots in this block whenever the owners of a majority of the frontage of lots so desire, for which each of the then owners of property adjoining said sewer line agrees to pay the pro rata part of its cost according to the frontage on said sewer line. These conditions are for the benefit of all present and future owners of property in this subdivision and are to remain in force until July 1, 1935, and shall then terminate. As we understand the record, the deeds all contain substantially the same restrictions. Lot 2 on the plat is a very large lot said to contain 4 acres. On it is the Wilcox home, built before the platting. It is a large substantial residence and faces Woodward Avenue. After substantially all the lots in the subdivision had been sold and expensive residences had been erected and improvements made upon them, making the neighborhood a high-class residential district, all in conformity with the restrictions, and without a breach by any of the purchasers or their grantees, Mrs. Wilcox, on May 29, 1919, entered into a contract with one Ben B. Jacob, a real estate dealer of Detroit, to sell him the Wilcox home together with part of Lot 2 for $47,500 to be used for restaurant or cafe purposes. With this clause in the contract, music, dancing and other legal amusements and uses are permitted. Mr. Jacob transferred the contract to the defendant Shelbourne Company, a corporation organized for the purpose of owning and operating the restaurant. There seems to have been a fruitless attempt to adjust differences, and this bill was filed by resident owners to enforce the restrictions. Property 434. The testimony in this ample record is convincing that to allow the defendants to transfer the palatial Wilcox home into a restaurant, no matter of how high a grade, would be subversive of every purpose prompting the restrictions, would reduce the value of plaintiff's property and that of other residents of the subdivision thousands of dollars, and would destroy the high-class, residential character of the neighborhood, which induced the residents to move there and to expend their money in developing. We recognize the rule that in construing restrictions ambiguous expressions must be taken most strongly against those seeking to enforce them, but we perceive no ambiguity in the ones before us, hence no necessity to resort to rules of construction. By each deed executed by Mrs. Wilcox she restrained the use to be made of the lot sold, and by accepting it each grantee and the lot conveyed in each deed became bound by these restrictions. By each of these deeds she covenanted that the Restrictions were for the benefit of all present and future owners. She was the present owner of Lot 2. By each deed she restricted the use to which the lot sold could be put, and by the same instrument restricted a different use of her own lot. The restrictions were mutual. Her grantees and the land conveyed were bound, and by the same instrument she and her residential lot were bound. When made, the restrictions were alike beneficial to her and her grantees, and she cannot now, having accepted the benefits of the restrictions, and the purchase price enhanced by them, disregard her own covenant and free her own land from its effect. Upon this record a clear case for the relief prayed is made against defendant Wilcox. The case of Williams v. Lawson, 188 Michigan 88, most strongly relied upon by counsel. For defendant Wilcox is clearly distinguishable from the instant case. In that case, there were certain restrictions on lots on the south side of the street. It does not appear that there were any on those on the north side of the street, at least there were none on the lot involved. The restrictions themselves on the lots on the south side of the street did not show that they were made applicable to the other lots, nor does it appear that the grantors covenanted and agreed that their remaining property or all the lots should be subject to the same restrictions. It was sought to show a general plan, but if such plan had been formulated, defendant had no notice of it. In the instant case there was a general plan, one originated by defendant Wilcox and her husband, one of which she had knowledge, and such general plan was incorporated in every deed she executed. Ch12, Restrictive Covenants 435. This leaves for consideration the contention of defendant Shelbourne Company that it purchased without notice of the restrictions and is, therefore, not bound by them. This presents the most difficult question in the case. Before considering the legal question, let us restate some of the pertinent facts. Defendant Wilcox originated the general plan of restricting all the lots in the plat to use for residential purposes only. This included the lot upon which her home was located. This plan she incorporated in the deeds executed by her, which were recorded. By these restrictions reciprocal negative easements were created alike upon the land sold and upon Lot 2. The question, therefore, presented is whether the recording of the deeds creating these reciprocal negative easements gave constructive notice to subsequent purchasers of Lot 2. The courts have not had this question before them with any degree of frequency. Long review of authorities omitted. Upon principle we think the rule adopted by their authorities is the correct one. By the deeds executed by Mrs. Wilcox, a negative easement was by her placed upon Lot 2. When these deeds were placed on record, this gave constructive notice of that negative easement. Defendant Shelbourne Company was not a bona fide purchaser and took subject to the rights of the plaintiffs. Upon the argument it was pointed out that the Shelbourne Company had expended some money and entered into engagements for the carrying out of the plan of converting the Wilcox home into a restaurant. But there has been no laches on the part of plaintiffs. As soon as they learned of the sale they at once took up the matter with Mr. Wilcox and the officers of the company. Failing by negotiations to secure their rights, this bill was filed. The decree will be affirmed, with costs. Notes and questions. 1. How, if at all, does McQuaid differ from Daily Drywall, which we read in Chapter 9's coverage of recording acts? Is Lot 2 ever burdened by an express easement? Property 436. 2. If the court assumed that no express burden attached to Lot 2, what legal theory could they have used to reach this conclusion? Is there a parallel approach for creating an easement? 3. Why does the court find that the restriction burdened Shelbourne Co. Sanborn v. McLean 206 NW 496, Michigan 1925. Opinion by Wiest, J. Defendant Christina McLean owns the west 35 feet of Lot 86 of Green Lawn subdivision, at the northeast corner of Collingwood Avenue and 2nd Boulevard, in the city of Detroit, upon which there is a dwelling house, occupied by herself and her husband, defendant John A. McLean. The house fronts Collingwood Avenue. At the rear of the lot is an alley. Mrs. McLean derived title from her husband and, in the course of the opinion, we will speak of both as defendants. Mr. and Mrs. McLean started to erect a gasoline filling station at the rear end of their lot, and they were enjoined by decree from doing so and bring the issues before us by appeal. Collingwood Avenue is a high-grade residence street between Woodward Avenue and Hamilton Boulevard, with single, double and apartment houses, and plaintiffs who are owners of land adjoining, and in the vicinity of defendants' land, and who trace title, as do defendants, to the proprietors of the subdivision, claim that the proposed gasoline station will be a nuisance per se, is in violation of the general plan fixed for use of all lots on the street for residence purposes only, as evidenced by restrictions upon 53 of the 91 lots fronting on Collingwood Avenue, and that defendant's lot is subject to a reciprocal negative easement barring a use so detrimental to the enjoyment and value of its neighbors. Defendants insist that no restrictions appear in their chain of title and they purchased without notice of any reciprocal negative easement, and deny that a gasoline station is a nuisance per se. We find no occasion to pass upon the question of nuisance, as the case can be decided under the rule of reciprocal negative easement. Ch12, Restrictive Covenants 437. This subdivision was planned strictly for residence purposes, except lots fronting Woodward Avenue and Hamilton Boulevard. The 91 lots on Collingwood Avenue were platted in 1891, designed for and each one sold solely for residence purposes. And residences have been erected upon all of the lots. Is defendant's lot subject to a reciprocal negative easement? If the owner of two or more lots, so situated as to bear the relation, sells one with restrictions of benefit to the land retained, the servitude becomes mutual, and, during the period of restraint, the owner of the lot or lots retained can do nothing forbidden to the owner of the lot sold. For want of a better descriptive term, this is styled a reciprocal negative easement. It runs with the land sold by virtue of express fastening and abides with the land retained until loosened by expiration of its period of service or by events working its destruction. It is not personal to owners but operative upon use of the land by any owner having actual or constructive notice thereof. It is an easement passing its benefits and carrying its obligations to all purchasers of land subject to its affirmative or negative mandates. It originates for mutual benefit and exists with vigor sufficient to work its ends. It must start with a common owner. Reciprocal negative easements are never retroactive, the very nature of their origin forbids. They arise, if at all, out of a benefit accorded land retained, by restrictions upon neighboring land sold by a common owner. Such a scheme of restrictions must start with a common owner, it cannot arise and fasten upon one lot by reason of other lot owners conforming to a general plan. If a reciprocal negative easement attached to defendant's lot, it was fastened thereto while in the hands of the common owner of it and neighboring lots by way of sale of other lots with restrictions beneficial at that time to it. This leads to inquiry as to what lots, if any, were sold with restrictions by the common owner before the sale of defendant's lot. While the proofs cover another avenue, we need consider sales only. On Collingwood